Just over a year ago, the U.S. Supreme Court decided a case called Cyan versus Beaver County Employees Retirement Fund that dealt with claims arising under the Securities Act of 1933. And that act, among other things, prohibits false and misleading registration statements. And the question before the Supreme Court was whether those types of claims can be brought in a class action format in state courts or if they had to be brought in federal courts. And the U.S. Supreme Court ruled that those kinds of cases could proceed in state court. There's a lot of nuance here, but there's kind of two things I'd highlight. One is that it's more difficult to get claims dismissed at the motion to dismiss stage in state court. And the statistics bear that out. I think the dismissal rate for these kinds of 33 Act claims in federal court is around 42%, and that drops all the way to a little less than 20% in state court. So it's much more difficult for defendants to get out of these cases at an early stage in state court rather than federal court. The other issue that defendants face in state court is that there's no automatic stay on discovery in state court. And so the plaintiffs could start issuing expensive discovery that needs to be responded to almost immediately upon commencement of the action. So those are two ways that plaintiffs have an advantage in these 33 Act claims when they're brought in state court. And plaintiffs have taken advantage of the Cyan decision because in the year leading up to the Cyan decision, there were only 11 33 Act securities class actions brought in state court. In the year after Cyan was decided, that number's more than doubled.